Ladies and gentlemen, I think one thing that we know after the first argument and after the evidence that's been presented is that this was one of the most horrible events that anybody could witness. I hope you don't think for any moment that the horror of what occurred, that the death of a girl, that all of that is somehow should be dismissed, because it shouldn't be. None of that is in dispute. None of that is a question here today. What you have to do is a job, however. You're just beginning your job. Our job is just about done. Your job will begin. Mr. Bost told you that there are certain tools that you have to do your job. I'm going to go through those here shortly. Then I'm going to let Mr. Bost talk, and then Ms. Shelton will finish up. Let me tell you, first of all, as emotional and as horrible as this is, you have instructions from the court on how you're to do your job and how you're to make your decision. One of those things is in paragraph 8, top of the second page, where it says, do not let bias, prejudice, sympathy, resentment, or any such emotion play any part in your deliberations. There was horrible emotion out there that night, but what you must do is set that aside and judge the facts. You are the judge of the facts. The judge has provided you the law. You now must evaluate the facts, and each one of you are individual judges. Remember, I told you about an individual verdict. But I also told you about a tool that all of you have, and that's your collective wisdom. So as you go through and evaluate the evidence, please share with each other what the evidence shows to you and what it means to you. Take time to talk with each other. We're not dealing about whether or not this was a horrible event. We know that. We're not dealing about the facts that happened. We know what happened out there factually. We're dealing about a mental state, and you know that. And that's been presented to you. We spent most of our time talking about it. So the tools that you have are the court's charge, which tells you not to use emotion. Also, there are definitions in here. Now, sometimes jurors will send out notes and ask for definitions that are not provided to them. The judge has provided you all the law that you're going to get. There's not going to be other definitions, other things, so you need to use this, plus the common definitions that we all understand, the words in the English language. So this will help you out. Mental disease and defect is not defined. You will not get a definition of it. It is there's no definition of what's wrong. You will not get a definition of that. If you, however, have questions about the evidence, you may send a note out, as the judge says in here, and you may ask to have testimony read back to you if you need to resolve conflicts. So you can do that. Otherwise, use your collective memory. That's a tool that you can use in making your determination. Other tools that you have are the records. There's a lot of records here. Records that Mr. Poole referenced here, or photographs. This huge medical record, which occurred a year before, which states that Mr. Lott was diagnosed with schizoaffective disorder, is available to you. I don't expect you to review each page or go through each of this. But if there's some sort of a conflict or something in your mind that needs to be resolved, this is the evidence before you. And you can use that, just as you can use the physical evidence and everything else that you have before you. Take it back into the jury room with you, and if you need it to resolve facts, use it to resolve facts. You have three options on each one of the verdict forms: guilty, not guilty, or not guilty by reason of insanity. Really, there's only two: guilty or not guilty by reason of insanity. That's the defense we put forward. We put the evidence out there. They've rebutted the evidence. That's the evidence before you. That's what you have to decide. The emotion, the horror, set that aside and make your determination on the facts, on what you heard, and on the reasonable inferences from the facts, or reasonable deduction from the facts. If there's something that you believe, fact deduced, then that can be the fact that you find. So discuss all of that. Each one of you has your own opinion on the facts, and you can share that with other people, and you try to persuade other people. Let me talk just about a couple of things, and then I will sit down. During the argument, there are four things that lawyers can argue. We can argue the evidence, which is here. We can argue reasonable deductions from the evidence. In other words, a deduction would be, for example, if Mr. Lott, 1 year before the event, had schizoaffective disorder, you can deduce that he had schizoaffective disorder on the day that it occurred. That's a reasonable deduction which you may make. State or the defense can make a plea for law enforcement, which is what I have done, to follow the judge's instructions, to reread them over, to consider them. And the last thing that we can argue in state is to answer whatever the opposing counsel said. We can respond to that, and they can respond to us. One thing, however, when Mr. Boss sits down, we do not have an opportunity to make any response to the state's final argument. They have the burden of proof overall in the case. We have the burden of proof on the insanity, but they have the burden of proof overall. And the final argument, they get that, and we can't respond to it. That doesn't mean there isn't a response. If there is something that you feel is important and it wasn't said, it doesn't mean it's not important just because we didn't say it. You remember Dr. Price said on the gun that there was dirt and grass on it, and that was not brushed off. In other words, that was evidence possibly that Mr. Lott did not know what he did was wrong because he didn't conceal that. He hadn't thought of that. Dr. Falls had thought of that. That's something that even between the two of them, they didn't realize. And there may be facts that each one of you can determine that fit into that type of category. Ladies and gentlemen, at the conclusion of all the arguments and the conclusion of your deliberations, we ask you on our side to find what the facts show. Mr. Lott is not guilty by reason of insanity. Thank you.